That's okay, which I don't think you have that here. That's the problem. Yeah. The next is, Don, you and I talked about it, page 42 to 43. This is a lawyer thing. There's a potential for confusion as to the appropriate standard review before the appeals board in the event of an appeal. There's no question it's the intent to be a preponderance of the evidence, but then you use the word clearly in front of wrong, which clearly, for clear and convincing, may be a different standard. We just proposed deleting the word clearly and just say the burden is preponderance of the evidence that the decision was wrong. I mean, so it's like a clearly erroneous standard. It's bizarre. And Dave, you may have some thought on that.
I'll have to think about it.
Well, it's a hybrid. I mean, I've told you this before, just so that people know here. The penalty section and the appeal section is perhaps the worst part of this FEMA ordinance as it is written. The appeal section is just incomprehensible. I mean, I tried to clean it up in such a way that kind of related back to what the common law is for the Board of Equalization and Review. And I thought, so I'm attempting to do that, and in utilizing the same standard. And the standard there is that the Board of Equalization and Review, when they make a decision, is presumptively correct, and that in that situation, the taxpayer has to come prove by clear and convincing evidence that the assessor was clearly wrong. That's the standard.
If there was a bill to change that, I don't know if it passed.
Yeah, I tried to I tried to adopt some of that. I'm not real comfortable, I'll just tell you, with any of the appeal sections.
It is better. I will agree with you. It's better than what was originally there. And you and I have had multiple discussions and multiple comments.
Yeah. But you would be satisfied if we remove the word clearly.
Absolutely.
Yeah.
Which I don't think
changes. You believe that it sets a different standard than by preponderance of the evidence.
Yeah.
Yeah. Okay.
And I don't think that's you're either wrong or you're right. And I think that takes care of that. Next comment is on page 43. That Kevin is probably FEMA language. Kevin might have to ask FEMA language. The question is whether permit applicant complies with the ordinance. If they do, they should get a permit. If they don't, the application and appeal should be denied. The way it's written is
what section?
8.3b1, page 43.
8.3b1.
B1. It adds language such as, in addition to considering whether there's an increase in the base flood elevation and reasonably safe from flooding, the appeals board should consider, and I'm not saying these things shouldn't be considered, but I think it is covered in the 1 foot rule and reasonably safe from flooding. Additional threats to public safety, extraordinary public expense, create nuisances.
Yeah, that's all FEMA, and I will tell you, I'm not comfortable with it all. If I were writing this clean of FEMA, I would delete the whole section.
Because let me explain to you guys, I don't want you to think we're trying to run and hide from anything, but let me tell you what happens is, those issues, when you talk about nuisances, fraud, those become civil disputes between Mrs. Huff and EQT, for instance. That's not really a fight that the county commission should get into. And so, that's our comment. I understand if FEMA says it's got to be in there, it's got to be in there, but that's our comment on that issue. And I'm assuming that if FEMA says it's got to be in there, there's no really reason to have other comment on the other side of it. So.
Well, what's not clear in that section is to what extent is the commission bound to consider those items, and what standard does that consideration take?
Yeah, I mean, the bottom.
Plus it started. The original thing originally only assumed that people would be appealing the denial of permit.
Yeah, that's the opposite.
Right. That's where the problem started.
Yeah, you're correct.
And so the issue, like with the nuisance, for instance, you may consider an oil and gas well nuisance. I don't know if you do or not.
No, the county commission, for example, they can deal with the nuisance of somebody's dog barking.
Well, I understand.
So why would nuisance stop?
Because if my client drills a well on your property, that's a DEP's jurisdiction, not the county commission to
No,
determine
it's not,
nuisance.
because they're here.
Well,
to
hold on, let me
protect
finish.
citizens.
It's a property right that a gas dealer would have, and therefore it cannot be legally a nuisance if there's a property right.
Yeah, that can be. What
And so-
some person does on their property, if it harms another person or their property, it is a nuisance. And that property could be mineral property or it could be surface property.
I'm talking about the legal definition of nuisance. I know you may consider nuisance. I'm talking about legal ramifications when I make these comments. Is what I'm
Well,
talking
that's the common law nuisance, nuisance court.
about. I'm going to mention.
I thought just because a person might have a civil remedy in court doesn't mean the county commission could consider it.
Well, I don't think they should step into the shoes of something that isn't outside their jurisdiction to determine whether it complies with technical requirements. That's the nature of my comment, which is also a reasonable alternative. I mean, while I'm on this point, we can talk about reasonably alternative locations. And I'm not going to dispute or get into a fight with you right now as to whether there was reasonably alternative locations, Mrs. Huff. We never got to that point in that case. We had our evidence and testimony. But the reality of it is, again, because development is permitted in a floodplain, if you meet the technical requirements, it's permitted. It shouldn't matter if there's another location. It's not your decision. Your analysis is to whether it complies with the floodplain ordinance and whether interest rates are going to go up. It does not. If we comply with that, then there's no harm. You've done your job. It doesn't matter if there's a result in terms of location. That's a property fight. That's not your job.
Mr. Tennant, is this entire paragraph FEMA wording?
Yes.
And I don't have problems with the entire paragraph, just
Because there's a section that was not in the original ordinance. But
Well, I said yes very quickly. I didn't even look at it, but I thought that we were in the section where it's all FEMA. But
We compared it.
if you give me,
Do you want to see what you changed? I've got a comparison.
read it to me. I don't have from me.
What was changed, a decision granting or denying the permit, he added that, shall only be issued by Floodplain Appeals Board. Floodplain was added. Upon showing good and sufficient cause, a determination that failure to grant the permit was added would result in exceptional hardship to the applicant. And 3, a determination that you took the out before the granting. You also took out of an appeal and replaced that with the permit. Will not result in increased flood heights. Then you added to any extent in the floodway area or in all other zones.
I recall that now. That was just an attempt to clean that section up. When I said it's all the FEMA language, it is, but I tried to word it in such a way that it made some sense.
Okay, so that reference to any extent, all other flood zones, base flood, see, that wasn't in the original ordinance. So you're saying you put that in there because it's FEMA's wording?
That wording was
Because
added.
that big, long sentence is brand new.
Are you talking about 83B1 Mr. Huff?
Yes.
Yeah, because I have a specific comment on that issue. I think that's going to be changed.
The original ordinance didn't have that reference in there.
You clarified.
Well, I think what I clarified was the issue of the difference between floodway and
You did.
and tried to make sure that it was clear that there was 2 different standards. One applies to floodway and the other applies to...
And I appreciate and I think that's a good distinction to make. I just think that the way it's worded is a little more confusing. With all due respect, I mean, I know you've been in this. We did propose a language to have that exact language to make it more clear.
Yeah, the issue was trying to keep as much of the FEMA language that was in that paragraph, and it's always awkward. I can tell you that if I sat down, I mean, I guess I'll use this analogy. If I were to paint the Mona Lisa, it would be easier for me to start with a blank slate and paint my Mona Lisa than to have you paint half of the face and then come in later and try to finish the Mona Lisa. And that's the problem that we had throughout the whole document because, I mean, and this wouldn't be negative to Kevin Sneed, but this was one of the worst written documents that I've ever read in my life. I mean, literally, you're an educator. I don't know what grade you taught in, but I'd hate to even say I would be being not considerate of a 6th grader by saying a 6th grade educated person wrote this darn thing.
Let's get back to the point, Don.
But,
No, I'm just kidding.
you know, I mean, this was really, really a horrible document.
Yeah, I agree, and I think it's much better